Just about 10 o'clock. So our topic today, ladies and gentlemen, is all about the all-important power of attorney documents. Some things that we want our realtors to know about them. Probably about 20 minutes we'll spend discussing these, just so you have a general idea of what's important about a power of attorney and what your clients also need to know. So without further ado, let's get started with our presentation. I'm sure you guys have heard this before. Hey, I can't come to closing. What in the world do you do now? Well, you probably have had scenarios like this one. Mr. Seller has an unavoidable emergency that's going to take him out of the area for weeks, and he can't come to closing, but he says his brother can attend on his behalf. A situation very similar, I'm sure, to what you have with your clients. Or this scenario, we have Mr. and Mrs. Buyer who are purchasing their first home. They're getting a loan with a local bank, and they find out that Mrs. Buyer has to schedule her C-section right before closing day. She will not be able to come to settlement, obviously. True story. Mr. Buyer naturally wants to sign on behalf of his wife so he can make things a lot easier for her, and they can also still close their loan on time. Both of these situations can be resolved with the smart, careful use of a power of attorney. Power of attorney is a wonderful document in its purest form because it can make real estate transactions a lot easier for everybody that's involved. And I'm sure that you have had that kind of a situation crop up in your career. So what is a power of attorney anyway? A POA is short for power of attorney. It's the legal document that allows a designated person to sign on behalf of somebody else, pure and simple. There are very special rights and responsibilities that are conferred to this designated person. So it's super important, everyone, that clients are very, very careful to designate someone that they trust. Now, a power of attorney is used only for individual buyers and sellers. It is used for people, let's put it that way. We're going to talk more about this in a minute. The parties in a power of attorney, there are 4 different people who are involved in the power of attorney. The first is the principal. This is the person who is conveying his or her signing power. This is the person that's not going to be at closing. We call them the principal. Next is the designated agent. This is the person that's signing on behalf of your principal. They're called the agent for the principal, but it doesn't necessarily mean that they're a real estate agent. It's just the person that's signing on behalf of the person who won't come to closing. Usually this is a husband, wife, very close trusted friend, or some kind of a relative. For a power of attorney in Pennsylvania after 2015, 2 independent witnesses are required. And neither the designated agent nor the notary can be one of the witnesses for the power of attorney. And then finally, we have the notary public. They're the person who will verify the principal's identity and make sure that they are not signing under duress. It's the responsibility of the notary to make sure that the principal knows what they're signing and that they are sane and able to make these decisions to have this executed. All of the parties to a power of attorney have to be 18 years of age or older. As I just mentioned, they all have to be of sound and sane mind and legally competent. The witnesses have to be able to verify or affirm that, yes, they did witness the principal signing the power of attorney. They all need to understand their rights and responsibilities under the power of attorney as well, because the agent is taking on a great deal of responsibility in the execution of this power of attorney. That should not be taken lightly. Sometimes I hear different folks discuss, oh, well, I'll just get a power of attorney signed. And it's handled very casually or in a casual manner, but it's really important that the agent for the principal really understand what it is that they're taking on. We'll talk about that in a moment. Here's a question that comes up from time to time. I hear people say that, oh, I've got a power of attorney for my deceased uncle, so we're still good, right? The answer to that question is no. A power of attorney is only valid while the principal is still alive. If your principal dies before closing, then we get into an issue where an estate has to be opened on behalf of that principal. And then an executor or an administrator is appointed depending on whether or not the principal had a will when they passed away. This naturally will delay closing for a short time to go through the estate process, but it's important. The most important thing to remember is that a power of attorney is only valid while our principal is still living. When can a power of attorney not be used? Well, it cannot be used in place of an executor of an estate. So for example, we have a situation where we have a deceased seller and they had a will that named an executor and the executor can't come to closing. Well, they have to go through the process of having an alternate executor named. They can't just use a POA for closing. Same is true if you have a client who is a trust. If a trustee cannot come to closing to sign on behalf of that trust, a power of attorney can't be used to designate an alternate signer. It's got to be a new successor trustee that is named. And we're not going to talk too much about that because that gets into a whole other area of discussion. A power of attorney also cannot be used in place of a member of an LLC or a corporate officer. As we discussed last week in our class on LLCs, we had mentioned that if you have a member of an LLC that is a designated signer, they will actually have to have a resolution drawn up among all the members so that a different designated signer can be authorized to sign on behalf of the LLC or a corporation. A POA also cannot be used if it's not completely signed and properly notarized. And finally, it cannot be used if our principal is deceased. There are several different kinds of POAs out there, but for our purposes today, we're strictly limiting our discussion to real estate power of attorney documents, of which there are two kinds. Basically, we have the seller POA and we have the buyer POA. The seller POA obviously will allow the designated agent to sell, lease, or mortgage the property on behalf of the seller. And the buyer POA will authorize a different individual to sign on behalf of a buyer, like for example, during a closing. Like in our example of Mr. and Mrs. Buyer, where Mrs. Buyer is scheduled to give birth, she obviously can't come to closing, so Mr. Buyer would sign on her behalf. The power of attorney generally has to be recorded at the county recorder of deeds office. And so recording fees are set by the county. And Watermark Land Transfer must have the original power of attorney in our possession to record after closing if it's not already been recorded. No exceptions on that. We have simply got to have it. So, whoever it is that is the principal or the designated agent, they need to work together to track down where an original copy of that is, or an original signed version of that is. Now, if the power of attorney has already been recorded at the courthouse, it makes our job a lot easier. All we have to do is simply download a copy from the courthouse records and review it to make sure it's been executed properly and everything. And also to see who has been designated as the signing agent on behalf of the principal. And as I said before, power of attorneys after 2015 have to have two witnesses. It was a change to state law. So if there's a power of attorney that has been signed prior to 2015 and there's only one witness, that's perfectly acceptable. It's really important, and maybe this goes without saying, that a person's full legal name be used on a power of attorney. We don't want to be in a situation where we have Don Williams. Is he the same person as Donald Williams? Is a person's nickname the same truly as their full legal name? Maybe, maybe not. So it's really important that we're getting their government issued ID to see how they are legally named so that the power of attorney can match that legal ID. A lot of details to review when we're discussing a power of attorney. So what powers does a POA actually grant? Well, let me get into a discussion of this quickly. It allows, of course, the designated agent to have the authority to sell, purchase, lease, mortgage, or otherwise encumber a specific property defined in the power of attorney. A real estate power of attorney, generally used for a specific closing, will name a specific property that the designated agent's powers are limited to. It's a lot more rare that I would see a power of attorney that's more general in nature that allows the designated agent power over everything that they own, but we do see those from time to time as well, particularly if we have elderly principals who have put powers in the hands of their children to sign on their behalf, for example. But generally, a real estate power of attorney is specific to a certain property. Now, the seller or the buyer does, of course, need to choose their designated agent carefully because they do have broad powers to act on their behalf. And if the designated agent has been found to be acting improperly or acting against the wishes of the principal, a court can take their powers away. So again, nothing to take lightly. Here is page 1 of a typical power of attorney. This is the power of attorney to sell real estate. And you'll notice that on this page, it's entirely in capital letters. It's designed that way on purpose by state statute to get your attention. And it's to alert the principal of the legal solemnity of this document, advising them that the power of attorney does not impose a duty on the designated agent. Rather, it's giving the agent powers to act on their behalf, to be used, exercised with care on behalf of the principal. And the agent is expected to act in the principal's best interests. Otherwise, a court can take their powers away. It does go through that. And the law permits the principal to grant broad authority to their designated agent as well. If there's anything about the power of attorney that a principal does not understand, we always recommend that the principal seek legal counsel to make sure they really understand what they're signing. Page 2 of a power of attorney. This is where the designated agent is named, who is signing on behalf of the principal in order to take care of business on behalf of the principal. It will also list the property address if this is a specific real estate power of attorney. And you'll notice at the bottom that there are spots for 2 witness signatures where the 2 witnesses will sign and also print their names below so that we know who they were. And again, one of the witnesses cannot be the designated agent or the notary. It has to be 2 extra independent people. These can be total strangers, naturally. It doesn't have to be anybody really that the principal knows, as long as the witnesses are at least 18 years of age or older. Then the notary will notarize the principal's signature. And also along with that, the notary is also going to make sure that the principal is not signing under duress, and also that the principal seemed to be coherent during the signing and that they seemed of sound mind. We don't want to get into a situation where we have a legal battle ensuing because a family member might charge that the principal was experiencing dementia and did not realize what they were signing. So it's very important that the notary be able to talk to the principal to get a general sense of their cognition when they sign.
Hey, Jerry, I have a question. So I have a buyer, and his dad was going to go on the loan with him, but the son has the full power of attorney. Mm-hmm. And he's like a totally disabled veteran. Mm-hmm. So the lender sent like I guess it was like a general POA to VA. And I guess they said they need like a specific one, but he's right. Like, he has no limbs. He cannot speak. Like, what do you do in that situation? Like, because I don't think he can sign a new one.
Yeah, so he may be able, there's a way for a completely disabled person to either make their mark, which would then be witnessed and notarized, or to indicate that they are giving consent. As long as the disabled veteran is able to give some kind of consent whether by some physical act, maybe they can nod their head or, blinking their eyes to show understanding. As
Mhm.
long as that can be obtained from the principal, then there's a way to notarize the document and get it signed on their behalf by making a mark. And
Okay.
yeah, so it's not very common, but it can be done.
Yeah.
And if the court would not accept that, then it's possible that maybe guardianship or conservatorship might be recommended on behalf of that veteran.
Okay.
Yeah, but that gets to do a whole other discussion. But in
Yeah.
general, as long as they're able to consent somehow to what's going to be signed for them, then that's okay.
Okay.
That goes along too. We do see to a lesser extent powers of attorney that are more general in nature, and they intend actually to give the designated agent power over bank accounts, everything that the principal might own, ways to dispose of assets, everything short of being an executor, of a will, really. So, but again, for our discussion, we're just talking about real estate powers of attorney. Once the principal has notarized the signature, once the notary has notarized the principal's signature, there's an agent acknowledgement page where the designated agent has to affirm that they do understand their duties and responsibilities of acting as an agent for the principal, for the power of attorney. And they'll sign this and date. This does not need to be notarized. But again, the notary would like to, even though they are not notarizing the designated agent's signature, we still want to make sure that the designated agent is aware of the rights and responsibilities and seems competent to handle the responsibility. So a buyer and a seller power of attorney are very similar documents. We touched on this before, that one of them gives powers to lease and sell and otherwise encumber a property, even draw up easements on behalf of a principal for a driveway or power lines or setbacks, etc. And the other, of course, the buyer POA gives powers to lease, purchase, and mortgage a property on behalf of the principal. So here's a question that comes up sometimes. Watermark Land Transfer is presented with a worn and torn POA that was properly notarized back in 1999, but it was never recorded. So do we have to accept it? The answer is maybe. We do have the right to decline to use a power of attorney if anything about it would appear suspicious. In this case, it being properly notarized in 1999 is wonderful if it was executed properly, but the question is, why wasn't it recorded right away? A power of attorney should be recorded as soon as possible after signing, because it will legally preserve the rights in a public format for everyone to see. So we would feel a lot better if we had an old power of attorney cross our desk and it was recorded properly right after signing. Does the lender have the right to review a buyer's power of attorney before closing? The answer to that question is yes. The lender is definitely going to require the review of a buyer's power of attorney prior to closing. So in our example where Mr. and Mrs. Buyer are expecting, the bank is going to need to see the power of attorney that authorizes him to sign on behalf of his wife at closing. That will become a loan condition, and it has to be met in order for that loan to be clear to close. Does anybody have any questions about our power of attorney segment today? It's a lot of information. So if you do have questions that come up later as you're thinking about what we've discussed today, just either drop us a line. You can send the question to settlements@Watermark Land Transfer, or just give us a call. And we're always here to answer your questions and make sure you understand all about powers of attorney.
Yeah, I have a question.
Yeah.
Does the witnesses is there any restrictions on the witnesses being related?
No restrictions on the witnesses being related. The only requirement is that they be at least 18 years of age or older and have the basic capacity to understand that they're witnessing someone sign a legal document. But they could be sisters, brothers, sons and daughters of the principal, absolutely.
And when does the power of attorney terminate, or is there a kind of like a length of time when it's in effect?
No, it's actually technically good for the principal's lifetime. So that's why it's so important. Now, in the case of a real estate power of attorney where the property is being sold, the power of that, the legal responsibility of the power of attorney would end when the property is sold. There's no more rights or responsibilities associated with that, you know, when the property is disposed of. So for more general powers of attorney, and specifically like health powers of attorney and other kinds of durable powers of attorney that are intended to manage all of a principal's affairs. Again, as you see sometimes with our more elderly clients who need help, you know, completing tasks because they're physically incapable, those powers of attorney are generally considered to be good for the life of the principal. It's a good question. Okay, well, if there's no other questions, we'll just wrap it up here for today. Thank you so much for tuning in. Really appreciate that. Thanks for watching, and we'll see you again next week. Take care, guys.
Thanks, Jerry.
See you next week. Thank you.
Bye-bye.
Thank you.